Thank you. Again, I appreciate your consideration of this bill, AB 2819, which protects tenants from being unfairly placed on tenant blacklists, which jeopardizes their credit and ability to obtain housing. Under current law, court records and eviction lawsuits, which are known, as you will know, as unlawful detainers or UDs, become public after 60 days unless a tenant wins before that deadline. UDs are supposed to be heard within 20 days of filing. However, following severe budget cuts and court closures, state delays have often pushed these hearings well beyond the 60-day mark. The most recent data from the Judicial Council shows that one-third of all UD cases are unresolved at 45 days. Now, why is this a problem? After the 60-day mark, the tenant's information is automatically made public, even if they're eventually never evicted. Companies capture and publish lists of their names, information that remains on a tenant's credit report for up to 7 years, and jeopardizing their ability to obtain housing. In other words, even if they eventually win their case after 60 days, they would still end up on this tenant blacklist, essentially being found guilty before being able to prove their innocence. There is no current mechanism to correct these instances. Landlords are not able to distinguish between problematic and innocent tenants, so they screen out innocent applicants. The affordable housing crisis is exacerbated, and this situation is impacting thousands of tenants around the state. In my city, we're talking 500 eviction lawsuits a year. In LA, we're talking 6,000 eviction lawsuits a year, and so on. This bill will prevent the blacklisting of innocent tenants whose credit and reputations can be ruined by requiring that court records remain sealed unless the landlord prevails in the eviction lawsuit. I want to just take a moment and thank the California Apartment Association, with whom we worked in the Assembly. We took a series of amendments developed in collaboration to ensure that this legislation reflects a balanced approach between protecting innocent families while also ensuring that landlords have access to timely and accurate information about tenants. And the California Apartment Association is now neutral. It's also worth mentioning that there's nothing in current law or in this bill that prevents a landlord from requesting references from any prospective tenant's past landlord. So with that, I'd like to turn it over to our witnesses.
Thank you very much. First witness, 2 minutes, please.
Jith Meganathan, Western Center on Law and Poverty. We are co-sponsoring this bill with the California Rural Legal Assistance Foundation. We're here because legal services offices throughout the state see tenants who are harmed by existing law every single day, and they're harmed in 2 ways. The first is landlords frequently file eviction lawsuits against tenants, and then they work out their disagreement. The tenant may have paid the rent, but the landlord lost the check. The landlord realizes the mistake. All is well. The problem is that the landlord doesn't want to pay the attorney fees and the filing fees to dismiss the lawsuit. And then 60 days later, the tenant shows up as having been sued in an eviction lawsuit. They end up on one of these blacklists, and years down the road, when they go to find rental housing, they find that they cannot. The second way in which tenants are harmed are those who have valid defenses, such as habitability, which is a priority of this legislature. They're so scared of ending up on one of these blacklists if their trial goes past the 60-day mark that they give up their defense, settle the case, and move out before the 60-day mark. We've worked for months with the rental industry, with the apartment associations that have been willing to come to the table, and as Mr. Chu said, we've taken a series of amendments to address concerns about potential serial abusers. We have an amendment that will allow attorneys to obtain judicial notice of sealed records. The records can be unsealed in subsequent eviction proceedings, so those records are available in a court of law. The second is, if a case goes beyond the 60-day mark, it goes to trial and results in a judgment for the landlord, it will be unmasked. And this is a very powerful tool for landlords, because what they're saying to a tenant is, you'd better be very sure that you have a valid defense if you want to go to trial, because if you lose, you're going to be unmasked. It ensures that only meritorious cases are going to go to trial. So we think we found an appropriate balance here between tenants' rights to privacy and their ability to find housing, and to landlords' rights to get accurate information. So we ask for your aye vote.
Thank you very much. Next witness.
Good afternoon. My name is India Cleveland. I'm a resident of Oakland and a proud mother of a 6-year-old daughter. I thank the committee for the opportunity to be here. In May of 2009, I was named as a defendant in an eviction lawsuit. I responded immediately by filing an answer with the court, but no further action was taken in the case. I later learned that the landlord had lost the property in a foreclosure, so soon after, I moved to another apartment in Oakland. At that time, I believed the lawsuit was over. After all, my landlord was no longer the property owner, and I had moved into another apartment, and there was no indication from the court that the lawsuit was ongoing, but that was not the case. When I began looking for an apartment last fall, all of my applications were being denied. More than 10 applications were rejected in a few months. When I inquired on why, I learned it was because of the 2009 eviction lawsuit, and it showed up on my credit report, even though I was never actually evicted. I also learned that the lawsuit was still pending in the court more than 6.5 years after it's been filed. As a result, I was unable to find housing for over 6 months. And that time, my daughter and I relied on family, occasionally hotels, until they got too expensive, until we were eventually homeless. We moved around so much that my daughter asked me where we were sleeping at night. It's only recently that I finally found an apartment. Before 2009, I have never been involved in an eviction lawsuit and have not been involved in one since. The current law creates a domino effect that makes it difficult to come back from. I support the bill because I don't want any families to have to go through what my family's still going through.
Thank you very much for your testimony. Much appreciated. Other witnesses in support?
Question of the Western Center representative?
Let's wait and have it all at once. Other witnesses in support?
Bill Hernandez with the East Bay Community Law Center in strong support.
Thank you very much.
Chair and members, Kevin Baker for the American Civil Liberties Union. If the government's going to be publishing information about people, it's important that it be accurate when there's such a fundamental right at stake. Thank you.
Thank you. Other witnesses in support? Are there any witnesses in opposition? Witnesses in opposition, if you'd step forward, and let's leave the fellow from Western Center here because we know there's going to be a question asked of you. Have our witnesses.
I'll move back with Mr. Chu. I'll move back here. You can take the front.
Yeah, okay. Good afternoon, gentlemen.
Madam Chair, members of the committee, Ron Kingston. I represent 4 regional apartment associations from Orange County, Southern LA, East Bay, and North Valley. We have been dealing with this matter for a very, very long period of time. Our landlords, first of all, heavily rely on the credit worthiness of every tenant applicant. They look to one particular standard more important than anything else. Did you pay your past rent? They look towards unlawful detainers as being a critical part. We are unaware that landlords customarily, usually, or even for that matter, frequently file unlawful detainers unnecessarily. It's expensive. It's not a good practice. We have never encouraged it, nor stated to the standard of which has been alleged. The second issue is that our landlords, that when they face an unlawful detainer and the tenant moves out, which is almost in every case, they stop the proceeding. They stop paying the proceeding because it's very, very expensive to pay attorneys' fees and costs associated with that to ultimately take that to judgment. Once they regain possession, that's it. That's the end of it. Now, as to the bill, we agree that Mr. Chu has some valuable elements to it. You must serve the tenant. You must serve the tenant in an unlawful detainer. We believe that's a valuable correction. 2, we also agree, as the chairperson observed, about that this still maintains the ability to get references. So our current landlords can check past landlords. But we know one thing is for sure, that the current landlord will always give a glowing report of someone who can be problematic. Third, we believe also very, very strongly that if it involves a habitability claim, that there are substantial legal protections for the tenants today. As was alleged, that there aren't. There are. Retaliatory eviction, very, very strong law. We've never resisted reasonable responses to that. 2, the law on harassment. Tenants cannot be harassed. There are significant consequences. 3, there's the law on habitability, very strong, very robust, very clear in terms of what the parties must do. So we don't see that this is a problem. The one thing that we strongly believe in, that we still should always have access to the unlawful detainers that don't go to judgment. They are honest.
Excuse me. You've had 3 minutes, a little bit too long for given our 2-minute. Would you wrap? But it's important information. Would you just wrap it up, if you would?
Thank you for the guidance. This is what we have offered and has been rejected. We have, instead of the bill taking the direction for a permanent masking, unless it does go to judgment or a settlement that happens, we have asked that if the tenant leaves the premise within a 60-day, perhaps even 90-day period, that be absolutely masked forever. That is a reasonable resolution as opposed to what is proposed in Mr. Chu's bill. And for now, we ask for your no vote. Thank you.
Madam Chair, members, Steve Carlson for the Apartment Association of Greater Los Angeles and the Santa Barbara Rental Property Association. We also oppose the bill. Wanted to bring to the attention the committee some of the issues that we deal with in Los Angeles in particular and in Santa Barbara to some extent. We don't agree with the problem statement here. We do not think that this has been a system that has led to the abuse of thousands of tenants, and I think that, as advocates, often we hyperbolize, and I think perhaps some of the sponsors of the bill might have done so here. One of the things we run into in both LA and to some extent Santa Barbara are on the defense side of unlawful detainers, these eviction defense companies, not necessarily legal aid, who ask for jury trials on unlawful detainers. That then takes you out months and months and months under this court system. It is hugely expensive, and therefore, for a landlord to guess wrong and not to have the information that the landlord should have in making an appropriate rental decision, if you guess wrong, you're in trouble for a long time. What we have run into is that the normal way these things work is that the defense asks for a jury trial, might cost $15,000 or $20,000 for the plaintiff to hire a lawyer, goes back to the plaintiff, the defense, and said, okay, we'll waive the right to jury trial. If you let my guy stay in another 2 or 3 months, waive all the back rent, and pay me $5,000 for my troubles and a little bit to the tenant. That's what we run into all the time. So therefore, if you're guessing wrong, you guess really wrong. So we think that this bill is not necessary. We don't think the system has led to this. As a matter of fact, masking was put in to protect landlords originally. The reason the masking law went into effect in the early 90s was because eviction defense outfits were reading the filings, running down to the apartment, throwing a flyer under the door saying, hey, we can keep you in your apartment 6 months rent-free, and they could. They do that in a slightly different way, though. So, we know that Mr. Chu has attempted to try to be accommodating in certain ways, but we think the bill goes well too far and puts a lot of our small landlords at risk, and for those reasons, we ask for a no vote.
Thank you very much. Other witnesses in opposition? Short and sweet, please.
Madam Chair, Pat Moran with Aaron Reed and Associates, representing the San Diego County Apartment Association. We're opposed to the bill for the reasons previously stated by Mr. Carlson.
Thank you very much.
Catherine Borg with the Western Manufactured Housing Communities in opposition.
Thank you. Any other witnesses in opposition? All right, bringing it back, Senator Hertzberg, you have the floor.
Thank you. I just want to talk to any smart guy. I've talked to him a lot. I don't agree with him, but he's a smart guy. Maybe I'm missing something here, but if a lawsuit's filed against you and someone does a credit report, it shows up. irrespective of all this other stuff with respect to landlord. You got a situation where you don't pay a bill, a utility bill, and then they report it on your credit report. When you go to become a tenant in some place, forget all this list stuff, you're listed on these reports. If you've had litigation, it's there, right? I mean, isn't that, whether it's unlawful detainer or a consumer complaint or a partnership dispute or whatever, those things show up under the litigation section on your report, irrespective of all this other stuff. Isn't that accurate?
Yes, sir, but the difference between the consumer credit reports that say Experian, Equifax, TransUnion offer is that those have to be litigated to a judgment before they appear on the credit reports.
What's true? It's a default judgment. I've had a situation where some stupid little deal. When I left here with Via Ragosa, it was left over, and I didn't know it was there, and all of a sudden I ran my report and I saw money owed based upon a court proceeding that I didn't even know ever happened.
A default judgment is something that has been litigated.
Oh, I see. It's still a judgment. It's a default judgment.
Whereas what's being reported here is merely the fact that someone has
filing.
Yes, just the filing. The other point is nothing in this bill or existing law prevents a landlord from pulling a tenant's credit report. If the person is not paying utility bills or has other unpaid debts, I think it's an indicator they may not be a tenant that they want. They're still free to do that.
I see. And basically what happens in the real estate business is there's companies who actually compile all this stuff and then put them out and put them on these lists that then impact people's ability to rent, even though there's no real conclusion. There could have been a whole host of circumstances that put you on the list where you're exercising your rights, where there could have been a mistake, where you couldn't have been served, where all of these things could have happened. And then the adverse consequences we heard today from this woman's story that she just told us, you end up finding yourself really frozen out of the marketplace, and you didn't do anything wrong to start with.
That's exactly right, Senator.
That's what you're trying to get to. Okay.
Just to add to that, Senator, current law says if you do not win your case within 60 days, you go up on that credit list. In other words, you could win it on your 61st day. You could be innocent and you're fighting it, and 6 months later you win it, but when you hit that 60-day mark, you go on that credit list. Again, very different from a default judgment. And it used to be in the past that these cases would get resolved before 60 days, but now with the backups in the courts, that's not happening.
Los Angeles County, that would be a Wu versus Hopkins case. For those lawyers in that case, it's the circumstance create the outcome. That's the story in San Francisco in the community that you represent, where in the late 1800s, all of the wood laundries were against the law. You could only have brick laundries. Only Chinese folks had wood laundries. And so the court said by operation of law, it was unconstitutional because it discriminated against folks of a certain ethnic background. In Los Angeles County, if you filed a claim, there's no way to get disposition in 60 days. So it's the Yickwo versus Hopkins case. Now maybe you might get that in Yolo County or Alpine County, but I don't think it's very much the case.
Well, I'll say Yickwo did happen in my district, and I understand the analogy. And I will say in LA County, 6,000 of these cases every year, of these eviction cases that are not resolved within 60 days.
EUDAs filed. It's just 6,000.
6,000 that are not resolved within that time period.
Approximately 60,000 are filed annually in Los Angeles.
Senator Leno.
Thank you, Madam Chair. Of course I am. More than that, I will express some support for the bill and for tenants. And I'm sorry I missed some of the debate, and I respect the specificity with which the opposition expressed concern, but I think your responses have been very, very strong and compelling. And in the scheme of things, again, one of the few non-lawyers on this committee, and probably in this room at this time, maybe I missed some of the finer points of the law, but for me, this comes down to a concern for due process. And in the broader view of our urban areas in particular right now, where there is denser housing and higher rates of tenancy, that tenants are under assault. Without this concern, it's just harder and harder between the astronomical costs of rents as well as the phenomenon of a variety of no-cause evictions that you just barely hold on to your housing. And so many people who don't own their homes right now are just at risk of losing their community all the social services that support them, their employment, their faith communities. It's not easy right now. And so if it's even on the line, and I don't think the way I've heard the arguments presented is even at the line, but in the balance of things, I think that tenants are fighting a losing battle in many cases right now, and happy to support the bill. If you are taking amendments, I would be pleased to be added as a co-author. Do you need a motion?
We need a motion, but we still have discussion. I've also got, so it looks like we've got discussion all the way around. Senator Wajkowski, followed by Senator Morlock.
The opposition raised the point to discuss thousands of dollars. They're in litigation, and I'm wondering, and you know, against the idea of unmasking. My experience has always been that when you try to get an apartment, you have to fill out this wicked long list, and they always ask for references. Is there anything in this bill that would prohibit the landlord or the prospective landlord from calling up? I mean, they ask for the references names. You'd say, are you a problem tenant? Isn't that the normal way this rolls?
There's nothing in current law nor anything in this bill that prevents a landlord from asking for that information as far back as they want to go.
So there's other tools that they have to try to determine who are the people that they don't want to rent to.
They can run credit reports. Again, they can look for references. They can do any kind of background check that they want. And in fact, again, if they're in a UD trial, they can even ask for evidence of other masked cases. So we provide that information if they're in that situation. But again, to your point of when a landlord's looking at a prospective tenant, those are all tools at their disposal.
Great, and I assume that you've talked with the opposition about, the problem is these things get resolved, and there's no motion to dismiss. There's a complaint that it costs money to file a motion to dismiss, and I don't know if there's anything, and I don't do UD work, so I wouldn't know that why courts are not on their own motion just dismissing these cases rather than having these people masked, but that's not the bill before us. It's just, it seems like there's some mutually beneficial avenues that people can go to if they don't want to spend the money, just have the court set on their calendar 59-day, if this thing's been resolved, and dismiss it, right? But
Again, Judicial Council wanted to retain the flexibility for each court to determine when they dismiss lawsuits that are not being litigated, and were resistant to a mandate that it happen on the 59th day. So, but you've hit on the underlying problem that these are filed, and there's no incentive for a landlord to incur the attorney fees or the filing fees to file a dismissal, and so people like our witness, Ms. Cleveland, end up blacklisted as a result.
Thank you, Madam Chair. Just a question on the credit agencies and whoever is keeping these or providing the services. Is not a tenant permitted to write a letter and put that on the file saying, I have this situation and it wasn't completed, but I prevailed? And is there an opportunity for a response, or?
It's an excellent question. Here's the issue. Both credit reports like those issued by Equifax, Experian, TransUnion, and these tenant screening reports are regulated by the Federal Fair Credit Reporting Act. That's where the similarities end. The issue is the fact that someone was named as a defendant in a lawsuit. Once it becomes public, that's a matter of public record. It's a fact, and there's no way to dispute that fact. And yes, you can write to them and ask that a statement be included as to the facts of the case, but most of this is happening online now, and landlords, type in the name of the person and other personal identifying information, and what shoots up was named as a defendant in an eviction lawsuit, and that's why it's not a fair comparison. Whereas if you paid your credit card bill on time and your credit card company made a mistake, yeah, you can dispute it and get it fixed because it's not the truth. But being named as a defendant is a fact, and so can continue to be reported.
Thank you.
So I have a question. I wanted to ask the Rental Association folks, Mr. Carlton. I'm a little unclear on how this bill impacts the sort of the game playing, you know, both sides do this, but how does this bill impact those who call for a jury trial, plaintiff seeking to remove a tenant who legitimately is not paying, or not legitimate, but is not paying their rent? How does this bill adversely impact the rights of the property owner?
I think the nexus I was trying to create, Madam Chair, was that this makes it more likely that you will not get information on a tenant that would have caused you to make a different decision in the application phase. And therefore, you will, you know, I think there'll be more cases that are masked under this circumstances, and therefore, we think that not every case that that was masked before, where somebody was a tenant that shouldn't have had their information public. So we think it's more likely that there'll be credit information that's not provided to the landlord that had he or she had that credit information would have made a different decision, and then you get into a very difficult situation, you know, once you're there.
So how, Mr. Chair, do you respond to that?
So this bill was, as I've referred to before, amended 4 times in our House to address issues that were raised by the apartment associations in California. And some of those amendments, I will mention, would permit landlords to pursue evidence in unlawful detainer trials regarding evidence of serial abuse. So in other words, if someone has had a record of being a tenant who's trying to game the system, the landlord is allowed, with the language now in this bill, to pursue that evidence and provide that evidence in a trial. And then to reiterate something that was mentioned by our representative from the Western Center, if a tenant decides to take this case to trial, and it's beyond the 60 days, that person does it with his or her risk, knowing that if she or he loses, this information is going to be on the blacklist. And so we think that's a very powerful deterrent to a tenant who doesn't feel like they have a meritorious case from proceeding to the end of that defense.
I could.
Very briefly, and I appreciate, I think this is a give and take. I'll give you a quick second and then a response. Okay.
Very briefly, the folks who are pushing this past the 60-day mark, as Mr. Carlson himself addressed, are people who are represented by attorneys. Most of those cases are going to settle, and there's probably going to be a stipulation for the records to be sealed anyway. Judges usually grant those stipulations, and so I disagree that the information that's available to landlords is going to be different in that situation.
Final word, and then Senator Hertzberg.
As Mr. Chu indicated, that one amendment to the bill was once you're in trial, you get to find out whether or not somebody else had been in trial before. In our view, once you're there, it's too late, and once you're in trial. So, you know, getting the information once you're there is, you know, for us, I don't think is adequate. So.
Okay. Appreciate the debate. Do we have a final, did you want to ask one?
I'll move the bill to a final comment on this. You guys in Harvard Law School together? You guys in class together? No?
A few years apart. A few years apart.
Years apart. Okay. But, you know, I have been a strong voice for the landlord community, not as the big landlords, but basically it's been my experience that lots of these guys are just little people that own fourplexes, and it's complex. And as we've spent a lot of time talking about Mr. Leno's measure involving a Section 8, as you recall, and I just felt with 1,572 pages of regulations and how complex those laws, I mean, how difficult it was to sign those contracts, it's hard for those folks to operate. And a lot of people get ahead in our society by in immigrant communities in particular, by buying a fourplex and buying something else. And quite frankly, that's the large element of that community. And so hence, I see it as an upward mobility element. But this is a completely different point. When Senator Leno raised the issue of due process, that's what this is. I mean, these are instruments that are used, and I understand that you want to find out as much as you can about your tenant, but without due process, with the manipulation of the process, these are, I think you're correct, so serious due process violations, I think, on a legal issue without even without this legislation that I'm hopefully gets signed by the governor, would have an impact, but to be able to make these determinations on people's lives, like Mr. Cleveland here, and you don't know what the facts are, to make an innuendo and to cause conclusions on people's lives, when you balance out the impacts and weighing what you're trying to weigh here and the long-term impacts, I didn't know how this process works, but I want to move the bill and commend you for doing it and just express that sensitivity because, as you've heard me talk about, I think it's legitimate. But in this case, this is a completely different dynamic, and I think it's a good measure, and let's move the bill.
Thank you, Senator.
Any further questions? Seeing none, Assembly Member, would you like to close?
I very much appreciate the committee's diligence and thinking this through. This has been a complicated area for us to move forward. But let me just close by saying you heard from Ms. Cleveland, and I know you have a rule here in this committee of only hearing from 2 witnesses, but we heard from others in our Assembly Committee. There are heartbreaking stories of what happens when you're actually innocent of what you're being charged with, but you're unable to defeat that lawsuit within 60 days. That is who we're trying to address, and we really are not trying to upset the balance that the law has that also assists landlords in getting information, particularly smaller landlords. So with that, I very much respectfully ask for your aye vote.
And of course, the purpose of the unlawful detainer action is to protect the rights of both parties. And I expressed some concerns to you earlier that we don't want to tip that balance. I think the due process issues are significant here. At the same time, if this starts to be a way to abuse the system, you know, as Senator Hertzberg mentioned, a lot of the landowners that have these rental units, frequently for them it's a 2-plex or 4-plex. They're not huge landlords, rather, and it's important that both sides try to work in a form of mutual respect, and that we create balances in those laws. But certainly, your point is well taken, and I appreciate the work you've done, and we'll be supporting the bill. So with that, we have a motion to pass to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, no. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wachowski? Aye. Wachowski, aye.
All right, that's 5-1. That measure, Senator Anderson will be back. We'll leave that the roll open for the absent members. Thank you, and I believe that concludes our item. Senator Chavez? Very good.